again, everybody. This is Doc with Thoroughfan, and last time we talked a lot about the legal challenge to the Horse Racing Integrity and Safety Act, which, remember, it is called HISA, not HISA. It's a long I. So we looked a lot at exactly what the legal breakdown of that legal challenge was, and there are a lot of people out there that feel that the legal ground that they are basing this on is pretty substantial, so it is certainly something to pay attention to. But of course, you know, the people and the legislators and all that went through all this trouble years and years and years of getting this bill finally passed are not just going to roll over and say, okay, yeah, you're right. For every argument, there's a counter argument, and that's kind of what we're going to focus on for this segment as we look more at HISA. We're going to take a look at exactly the rebuttal or the response to a lot of these claims that were made in the main lawsuit that is looking to have HISA declared unconstitutional. So come along once again as we delve a little bit deeper into the legal morass of HISA and its challenges. So, the response we are going to focus on here is the one submitted by the three lawmakers responsible for getting HISA in its current form across the finish line, so to speak, and passed into law. They are Representative Paul Tonko, Representative Andy Barr, and what was then Senate Majority Leader Mitch McConnell. Again, we are going to really focus on the many legal arguments here and not every problem that many have voiced with HISA. First, they respond to the argument made by the plaintiffs in this case, the National HBPA, many state HBPAs, and a few others, that HISA never underwent the proper legislative scrutiny. The brief states that this is not the case, as it outlines the various forms HISA has taken over the past 7 years or so, which actually is an interesting read when you look at how the bill has changed over the years, and that 2 full hearings were held on the bill under the auspices of the House Energy and Commerce Committee. In addition, they say, it was debated in the House Energy and Commerce Committee before being moved to the House floor for a vote. The brief also refutes that no debate on the House floor was done before HISA was passed on that voice vote of the House members. Citing the transcript of the congressional record, they show that debate did happen on the House floor before the voice vote passed. Well, I suppose you could call it a debate, even though all that spoke during that time, both in the majority and minority parties, all rose in support of the bill and no one spoke in objection to it. Now for what appears to be the real crux of the legal arguments here, and that is the constitutionality of HISA from a non-delegation doctrine and intelligible principle standpoint. We explained this argument in our last segment on the law, and you can find a link to that video at the end of this one. The brief states that it is their belief that the argument of violation of the non-delegation doctrine actually falls more under a due process one than a non-delegation one, but in response to the latter, they appear to base most of the argument for constitutionality of HISA on what is known as the Maloney Act of 1938. This act created a very similar type of agency to the HISA authority, according to the brief, and the way this private entity, now called the Financial Industry Regulatory Authority, or FINRA, interacts with the federal government's Security and Exchange Commission is the same way the HISA authority will report to and work with the Federal Trade Commission. They argue that FINRA must have any rules or regulations they impose on the financial industry reviewed and approved by the SEC, the same as the HISA board must do with the FTC and their proposed regulations. In addition, it is argued that the Maloney Act gave FINRA the power to investigate and adjudicate matters before them, but they could not act completely independently as they are always under the supervision of the SEC. HISA, they claim, would work the same way. I'm trying not to get too much into the legal weeds on this one, as one can very easily get lost down a never-ending wormhole of decisions and opinions. The crux of this argument-counter-argument issue at play here is that the plaintiffs bringing this lawsuit to have HISA declared unconstitutional are claiming that HISA, in its approved form, gives power to a private entity it should not legally be allowed to have, and that the claimed oversight that the FTC would have over the HISA board goes outside the accepted realms of federal control of a private entity. The defendants of this lawsuit, who are looking to have the case dismissed in federal court, are countering that it does fit all the tests of being constitutional by pointing out how it was modeled after the Maloney Act, which has withstood numerous court challenges, and another law called the Bituminous Coal Act of 1937, as well as decisions made in lawsuits challenging it over the years. They are arguing that, while the plaintiffs state the FTC has no real power over what the HISA board does and does not do, it actually does, just in a slightly different way because the FTC still has to have the final say on all approved or disapproved regulations or rules put forth by the authority. So while the FTC cannot write the rules themselves, so to speak, they can still offer suggestions as to how to word things while also just continuing to reject the proposed rules until they fit what it wants them to say. You can read the brief in full talking about all these cases using the link at the end of this video. On the plaintiff's argument that HISA allows private citizens to basically regulate their competitors, the defendants counter that is not the case because the majority of the HISA board must be independent people not involved in horse racing, and the other members must have no current financial ties to the industry. Therefore, there would be no incentive for them to act this way. The one thing I did find interesting about this response brief and support of the motion to dismiss this lawsuit is that it never really went into one of the other arguments brought by the lawsuit, and that was how the HISA nominating committee and subsequent members of the HISA authority board were chosen. It also did not address the allegation that the FTC or the federal government really has any control over removing or appointing new members to the authority board, since the law only allows the authority board to do that. This, again, would fall into the non-delegation doctrine aspect of the legal challenge to HISA. More briefs and appeals of decisions are surely to come of this, no matter how the initial court rules. Many see this going all the way to the Supreme Court if they agree to hear the case. It is a different Supreme Court makeup than in years past now as well, so exactly how the court would see this argument is very much yet to be seen. So I hope that gives everybody at least a little bit of a general understanding of what the crux of a lot of the legal arguments here and the argument on one side, the counter argument on the other side, the claim on this side, the counterclaim on this side. And this is the legal world we live in, folks. This is the process that a lot of laws that are recently enacted sometimes have to go through, and we're just going to have to watch to see how this all plays out. Again, as I said last time in the last segment, and as certainly will reiterate for this segment, I'm not a lawyer, I'm not a legal scholar in any way, I'm just trying to interpret this as best I can to try to hopefully make it a little bit easier for everybody to understand. And of course, if you are a lawyer or somebody who's really interested in this stuff, and it is interesting when you really delve into some of the arguments that are made, you certainly can research it a lot more on your own, and come to your own conclusions. That's kind of what we're about here at Thorofan. Thorofan does support HISA, and we are behind it, and we do hope that it does become, declared constitutional and eventually is enacted, because we do really feel it is what is needed for this industry really to start to thrive again. So we do really hope that any legal challenges will be dismissed over time. But of course, all of that, as we've said, remains to be seen. So there's one other aspect of HISA that we really haven't touched on just yet, and that's going to be the focus for our next segment, and that's how some of these other groups in the racing world, so the quarter horse industry, the standardbred industry, racetrack veterinarians, we're going to kind of focus on those guys in the next segment, look at how they view HISA and what their recommendations are, and if they are in support or not support of it, and for what reasons. So stay tuned for that. We'll have that out probably in a couple of weeks. In the meantime, if you do have any of your own opinions on HISA, be sure to send them to us here at Thorofan. We certainly will try to address them as best we can. And as always, if you are looking for the most accurate and up-to-date racing information for the racing fan, by the racing fans, there is only one place you definitely want to turn, and that is right here at Thorofan.